All right, we're going to start this video of explaining how it was presented to the public, the statute of uses, and what was the reason. Now, this is kind of reflective of how we are presented uh, things within the system. We are presented through the eyes of what the government has a right to administrate over, and we're only getting that window or that little room, if you will, of information that they are with right to speak about. They don't. Government doesn't speak to the common law, nor does it speak to the monarchy's interest, in as much that it doesn't teach those predominantly. It's sort of like a history lesson, and then it only explores for the next three terms or how many different years when you go into law schools and stuff like that. Those interests that have been created therefrom, which is now subject to the law of property, 1925, which only deals with the fee simple and those leasehold agreements. It's just funneled down to those agreements subject to a trust for sale scheme. Okay, it doesn't speak to bring into the courts to any great degree discuss the Settle Land Act, to identify where your true interests are originating, what's the position of the monarchy as fideicommissium, who's holding that interest um, through law or holding that right through law. Because again, through titles, it's only a fictional concept they hold, not the actual soil and land itself, because that's held in man through his own dominion interest. Okay, so let me read from here. And again, don't take my word for it. This is my interpretation. I know that people that study this are, and I'm sure law scholars are, contorted and bent out of shape the way that I explain it. That's okay. What we're trying to do is to arrive at the factual basis to whereby it is seen that everything has been set up for our benefit, where that then arrives us into our true inherent power, as opposed to being stuck within those agreements that have been created through operations of law that then we assume by our own actions of not coming to terms of what those agreements are. Okay, let's see where that is. Okay, and I've got so many tabs open. It is, and hopefully I don't have to pause the video again for. Oh, here we are. Okay, this is the Statute of Uses, Wills, and Enrolments, and I'm going to attach a link. In fact, I think I already attached that link in the subsequent videos, and because it also includes, the enactments of the wills or statute of enrollments, statute of wills, 1540, and that kind of thing. So you have a better, concept of how from this point it had evolved from for the rights of the use to be uh, extinguished in the common law to create one single title that common law recognized, and then where we moved into the trust to which equity dealt with, and therefore Parliament. Okay. Statute of Uses, 1536, 27 Henry VIII, Chapter 10, Statutes of the Realm, Volume 3. Okay, it says, whereby the common laws of this realm, lands, tenements, and hereditaments, be not divisible by testament, nor ought to be transferred from one to another, but by solemn liberalization, matter of record or writing sufficient, made bona fide without coven or fraud, yet nevertheless divers and sundry imaginations, subtle inventions and practices have been used whereby the hereditaments of this realm have been conveyed from one to another by fraudulent fiatments, fines, recoveries, and other insurances craftily made to secret uses, intents, and trust, and also by wills and testaments, sometimes made by nude paroles and words, sometimes by signs and tokens, and sometimes by writing, and for the most part made by such persons as be visited with sickness in their extreme agonies and pains, or at such time as they have scantly had any good memory or remembrance, at which times they, being provoked by greedy and covetous persons, lying in wait about them, do many times dispose indiscreetly and unadvisedly their lands and inheritance, by reason whereof, and by occasion of which, fraudulent fiatments, fines, recoveries, and other like assurances to uses, confidence, and trust, divers and many errors, have been unjustly at sundry times disinherited. The lords have lost their wards, marriages, release, herits, escheats, aids, profits, chevet, blah, 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 French. And scantly any person can be certainly assured of any lands by them purchased, nor know surely against whom they shall use their actions or executions for their rights, titles, and duties. And also men married have lost their tenancies by the courtesy, women their dowers, manifest perjuries by trial of such secret wills and uses have been committed. The king's highness hath lost the profits and advantages of the lands of persons attained, and of the lands craftily put in fiatments to the uses of aliens and born, and also the profits of waste for a year and a day of lands of fallen attained, and the lords their escheats thereof. And many other inconveniences have happened, and daily to increase among the king's subjects, to the great trouble in quietness, and to utter subversion and ancient common laws of this realm, and for the usurping and extinguishment of all subtle practice, fiatments, fines, recoveries, abuses, and errors heretofore used and accustomed in this realm, to the subversion of good and ancient laws of the same. And it goes on. I don't think I need to go on with it, but extract what we spoke about before, where who was making all the money at the time? Well, the lawyers were created are an instrument of the corporation, the Roman Church, and because no one knew who was holding what, lawyers were making money hand over fist, charging forever how much it took to uncover if the title was good or not, based on his ability to go back as far as the title was created. Now, people were creating uses upon uses upon uses. Every time a new person would get a use, then they say, well, hold it. If I got a use, well, I'll create another use on this use, and then I will sell that, to which that person did. And everybody was acting as kings and lords, and, So the point is, the law's not bad. The law is secured. It had to solve the problem, okay? People, the lords that were involved in at that time were circumventing the law to the extreme that fraudulent conveyances were experienced all over the kingdom. And of course, when you're doing is filling up the courts, and you're filling the pockets of lawyers, and there's much uncertainty. So how can you then create a foundation in which to establish certainty? And that's what English law does. Remember, it doesn't rule people, okay? Because you have dominion, and slavery is abhorrent to English law. What it does do is then, through the evolution of man wanting interest in land, it had to then react to where we're at now in equity, which is arbitrary. And it will just continue ad infinitum based on those new cases that come in. Common law settled. And you can see right there, he said the highness. If I don't think I'm going to be able to find it directly through my, just pinpointing where it said that. Oh, here it says, the king's highness has lost the profits and advantages of the lands of the persons attained, and of the lands craftily put in fiatments to the uses of aliens born, and also the profits of the waste for a year and a day of the lands of felons attained, and the lord's escheats thereof. had to say we have to create the separation, the division, whereby from that point, and what the trust does, the trust is your pivotal point, your vector, from which now it separates the common law. And what's the common law, the English common law? It's this vector point which separates your dominion rights. They're all separated, and we have advanced in this, in our means to become free, and we've, through sovereign movements and freedom movements and other practices in equity, that we're commingling everything. We're saying, I am this, I am man. Yeah, okay. Yeah, you are. That has never changed, but it's subject to another jurisdiction of self that is not even seen in common law because it's separated. And then we're bringing in, well, I have a right to land because I am man. I have, to which now we're bringing in common law interest, and then we're associating sometimes a common law interest to which is the common law within our territory run under government instead of the common law, which is subject to the English law, to where your true rights exist and have a rights to, because it's a hierarchical system of land holding, to then bring in another interest of equity. Well, I have rights under the Constitution, or I have rights to this land that I made purchase through, which is a purchase under trust for sale, to again then bring in another element. Therefore, commingle. And all the judge can do, so the judge is not at fault. I'm not saying that there's not a lot of maliciousness going on and fraudulent and it's enormous of everyone playing and trying to grab as much as they can within the system. I'm not saying that doesn't exist. What I'm saying is that whether the judge knows or he doesn't know, he's automatically triggered to go back into constructive trust because you haven't even brought the trust in to be measured against, or brought your status incorrectly, to whereby he's not going to throw your ass like the rest of them because he's saying, hey, I got to deal with you in this means because you have not brought me what I need in order to affect what you're looking for because you're commingling everything. All right, I think the next video, what I'll do is I'll do a quick overview of the points, and I'm going to have to put that together, a point form of what we learned through this segment statute uses, and then we'll go into the Steswa key because that originated, not even though it started in I think in 1485 with Richard III, who had to get a means in which to transfer those interests that he held as a fiat-offer, or a fiat-fee for the beneficial use. So he created a statute in order to do that. But moving to the 1540 Steswa, and then to move into 1707. I'm not going to deal with 1666. Okay, I know a lot of people like to go into that. To me, it just doesn't do anything except create another level of the Aristotelian approach that we're trying to navigate, where what I'm trying to do with, hopefully with others like you who can, maybe better discern the law better than I can, to bring in your understandings of what it's saying so we can go to Occam's razor and bring it down to one principal fact. That's what I'm looking to do and achieve here. All right. And hopefully I'll get better explaining things too. Here we go.